From the News Channel 5 Network, this is MorningLine with Nick Beres.
Joining us on MorningLine, Nick Beres here on a Monday. We have a good show on tap for you. We're going to talk the law, some legal issues as it pertains specifically to this issue of whether or not juveniles are sentenced too harshly in the state of Tennessee when it comes to certain crimes. And we'll get into that. There have been some interesting decisions coming down from the Tennessee Supreme Court of late that may change the way how long you can keep juvies behind bars and what they're sentenced to. We'll take your calls and questions as always, and it really is a fascinating topic in a time where we see more and more juveniles committing more and more serious adult type crimes, and how it will be handled and what it all means. For that, and to talk about some other legal questions as well this morning, is a very well-known local Metro Nashville statewide attorney. Everyone knows who David Raybin is. Good morning to you, sir.
Good morning, sir.
It is good to see you.
Yes, sir.
Thank you for coming on.
You're welcome.
This is a topic you've been on a number of programs in the past on various issues. This, you're very schooled on. Listen, just before we get to that, I just wanted to ask you this too, because I get messages all the time, and I know you work with Kim Hadi on the Lindsay Lowe case, and I know there's only so much you can say, and I've talked at length with Kim, who's done a wonderful job. But as it stands now with regard to, can you just tell us where things stand with Lindsay Lowe? She's out. I talked to Kim over the weekend. As a matter of fact, my understanding is that Lindsay's working. She's living with her family. Where does it stand with regard to moving forward to her?
Sure. Well, the judge released her and ordered her to live with her family. This was something that Judge Gay decided, which is fine. The state is appealing the granting of a new trial. That case will be, the state will appeal that, and that'll be argued in the Court of Appeals and maybe the Supreme Court over the next year or so. But unless that court reverses the Judge Gay's decision, which I don't think they will because it's a matter of the judge's discretion, then she'll get a new trial and it'll start all over again, and there'll be a new trial on the whole case.
Can you give any insight? Because I was talking to Kim about this, and she's in agreement, and others I've talked to same. It was the judge's discretion to order this new trial. But what type of argument could that be on appeal and challenging the judge's ruling?
I don't see how. The judge made a decision that, this is something that the judge ruled, that the juror lied in court to the judge himself about whether she had formed an opinion on the case, and it was inconsistent with her juror questionnaire. So she said one thing in there and another thing directly to the judge himself, not just to the lawyers. So when the judge made a finding of fact, the juror lied, therefore became incompetent to be a juror, and under the law he said he had no choice but to grant a new trial. This is not only a matter of judge's discretion, the judge made the right call on that. So when you have a juror who lies about a material issue, the judge, this case is from 1900 in the Supreme Court. So I don't know how, unless the state can somehow change the law on that issue, I don't know how they could prevail. So I think inevitably she'll have a new trial and another jury will hear the case.
I've also heard it appears as though, and I didn't think either of us expected this to happen, that the juror involved in this is not going to face criminal charges, as far as I know.
No, the district attorney has discretion to charge that person or not, whether to bring criminal charges against the juror, and that's the district attorney's decision.
And as far as just moving forward, that appeal slows things down. That's going to be sometime next year, maybe heard. After that, you say a new trial for Lindsay Lowe. That's if there's a new trial. Is it a given that she will be tried again, maybe in 2024 or 25?
Well, I don't see the district attorney dismissing the case. The matter would be set for trial and it'll be considered in the normal course of proceedings, but it'll be start all over again.
But all this time later, David, I mean, she already served 9 years. And I'm just saying, yeah, you're right. They're not going to just, is it hard getting the witnesses, the evidence, getting all that stuff back together again after more than a decade?
Well, that'll be up to the state, but again, the defense has the same issue. They're going to have to get their witnesses together again and present a different case. But that's for later. Right now, the issue is the appeal and holding that.
Gotcha. Just wanted to get an update on that front.
Sure.
All right, let's get to the issue at hand that I think a lot of people are going to be interested in this morning. And I say this first because time and again, we see youngsters committing more and more serious crimes. And if you're just looking at the surface of this, you're like, well, wait a second. Tennessee has 2 harsh juvenile sentences. Many of the viewers out there are going to say, it's not harsh enough. They commit crimes and they're out there walking around the next day. Put this into context for me, what we're talking about.
The Supreme Court of Tennessee issued a very narrow ruling that life without parole for juveniles is unconstitutional. But it's only where there is a murder case that the court has said that cruel and unusual punishment applies in that context. And so life without parole with no chance of ever getting out in their reasonable lifetime violates the Eighth Amendment. And then they said that they're not going to let them out. All they're going to do is make them eligible for parole after between 25 and 36 years. But then it's up to the parole board whether to let them out or not. But you're talking a quarter century or more, even for the defendant who prevailed in that case. So they're not opening the doors for these folks.
Why do you think this was an important ruling?
It's extremely important ruling for two reasons. First of all, our legislature is going in this direction with all the sentences going up, doing away with parole. This is a step in the right direction that returns the law to the way it was in 1989 when the Tennessee Sentencing Commission decided, and I was a member of that life sentence means 25 to 36 years, unless the jury finds life without parole or imposes the death penalty. So in Tennessee, you have three choices: death penalty, life without parole, or a life sentence with 25 to 36 year parole eligibility.
Eligibility doesn't mean you get it.
Correct.
Right.
It's eligibility. Well, the legislature in 1995 said, oh, we're going to do away with parole functionally, and made a life sentence 51 years. Well, that's a functional life sentence. So you have two life without paroles, which is absurd. It was the longest life sentence for juveniles anywhere in the whole country. No other country in the world does this, but in the United States, even for juveniles, Tennessee's 51 years for juveniles is the longest anywhere in the United States.
Do you know, on record, what's the youngest juvenile that's been sentenced to that sentence?
14.
A 14-year-old was sentenced to life in prison without any chance of parole.
Functionally, it was 51 years, but
51 years.
Yeah, I mean, the life expectancy of a person in prison is about a third less than a person not in prison. Some people say half. So these sentences were functionally life without parole for someone who was 14, 15 years old. And in some of these instances, they didn't even commit the murder themselves. They were an accessory to someone else committing the murder. And the judges had no discretion. And Nick, that's the problem. That's why the Supreme Court struck it down. The judge had no discretion. If the jury comes back and says guilty of first-degree murder, bang, it's an automatic life sentence. There's no sentencing hearing. The judge doesn't get to do what judges normally do, and that's weigh the various factors and impose a sentence.
For instance, in a case like that, maybe with this 14-year-old or another juvie, what are the factors they would look at when the jury comes back with guilty of first-degree murder, juvenile? What factors come into play with sentencing, would you say, if the judge has discretion?
Well, in this particular case, because of the way the law is structured, the Supreme Court said, unfortunately, the judge doesn't have any discretion, but if you kick parole back to 25 to 36 years, then the parole board has a discretion, as long as some entity has discretion, whether it's a judge or a parole board. The factors are, what are the facts of the case? What is the record of this juvenile? Is the person incorrigible? Have they committed multiple other crimes before? What is the prospect for rehabilitation? What is the psychological makeup of the person? Are they close to a mental defective situation where their mental facilities are not normal? They have emotional challenges, physical challenges. They may have been abused as younger children themselves. All those sorts of factors. And those are mitigating factors. And then you weigh that against the facts of the case. Was the victim a very young child? Was the victim a police officer? Was it a shooting another person during a drug deal, where commonly we perceive the culpability there somewhat less? So you weigh those factors, and then the parole board could say, okay, it's too serious, we're not going to let you out, even though we've considered these factors, or we'll let you be paroled. As long as that structure exists somewhere, either the judge or the parole, then it's constitutional. But our statute did not allow for that. And that's why the Supreme Court struck it down.
Yeah, you said that the state legislature is going in the opposite direction in some ways. And I don't know if you have a thought on that, but politically speaking, you're guessing the constituents are all about, I want you to be tough on crime, and they pass these things without really thinking about the consequences down the road. What do you think?
Well, this has always been, we've had this since 1829 when we went from branding and whipping people to the penitentiary system. And I sent you that article that I wrote.
Yeah.
People were supposed to sit in the prisons and do penance, which is why they call it a penitentiary. And so they had no parole, there was no probation. And then little by little, people recognize you have to give somebody an opportunity to be released. So we've had parole as a system since basically 1829. The governor did it, and then in 1913 they had a parole board. But there's always been at least an opportunity for parole. Our legislature this last year did away with parole for about 15 or 16
that whole
offenses.
truth in sentencing.
The truth in sentencing.
Yes.
So they're going this way, upwards, removing it. And then we had those horrific crimes in Memphis, where within 2 or 3 days, this young woman lost her life. She was kidnapped, raped, and murdered.
While she was out running.
Well, she was just feet from her own home. In her own neighborhood, a more horrific case I cannot imagine, by a guy who had just gotten out of prison. And then within a day or so, you had some person just running around the streets, wantonly killing, what, 2 or 3 or half a dozen people? So you had this immediate reaction, appropriately so. What the heck is going on? How can these things happen?
Why are they out?
Why are they out, or how did this happen? The person who killed all those folks had not been in prison, and so the legislature had a meeting where we're going to increase whatever crimes are left that we haven't done away with parole. We're going to do away with it. The juveniles, we're going to look at them. We're going to revisit all of that. So Tennessee is going in the other direction from most of the states in the United States, which are mitigating the punishments or allowing for parole. Under the idea of the rubric of truth in sentencing, which means whatever you want it to mean.
Right.
So soon we'll have a system. This has happened in 1979. There was a Class X felony law, which I helped write. Did away with parole for some offenses. And Governor Alexander was behind that. I was in the district attorney's office, and a couple of people, we worked on that. We thought that was the way to go. Within 6 years, we had riots in the prison, $11 million worth of damage. Guards were being held hostages, nurses were being held hostage. It was a catastrophe.
Too crowded.
Huh?
Too many people, too crowded.
It was
being
too
held.
crowded because there was no release mechanism.
All right, hold your thought on that. We have to take a break. We're up against it. When we come back, because I would like to hear, if there's some viewers out there, thoughts on the truth in sentencing, the thoughts on this. I know many of you, as David just said, we're aware of those cases out of Memphis. They're scary, and the knee-jerk reaction to that, and making sure that doesn't happen again. But on the other side of the coin, what are the drawbacks of this truth in sentencing where there's no parole? And with locking up a 14-year-old for the rest of his life, which, by the way, you're paying for. So let's get into that and more with David Raybin when we come back after this.